Hello everyone, welcome to the Beach Investing Legal Series with Shell Rothman. I am your host, Andrzej Angelkowski, and today is an interesting topic of hidden damage found on a property before or after you've purchased it. So I guess understanding when to disclose things, when you don't need to disclose things. Shell, please shed some light on this, will you?
So the biggest thing about seller disclosure is if you are specifically asked the question, you have to answer it honestly. So if there was a murder in a property and somebody asks you, has there ever been any suicides or murders in this property, you have an obligation to disclose. If you are not asked the question directly, you don't have an obligation to disclose. However, if you have a real estate agent, they do have an obligation automatically to disclose all information, pertinent information, to the buyer. That is within their knowledge. So if they could go onto Google and on the first page and find out that there was a murder in the property, it has to automatically be disclosed, whether or not their seller has provided that information to them.
So, but how do we know what is something that we need to disclose? So I didn't know I need to disclose a murder. Like, how do I know that that's something that is pertinent, pertinent information?
If there is a stigma to the property, so ghosts, murders, suicide, there has been a grow up in the property. Any of these things that has a stigma attached to it, obviously with the grow up there's also environmental and health issues involved, it has to be disclosed. The grow up needs to be disclosed just because of the health aspect, you would be liable. The other issues that were stigma, again, the seller does not have to disclose it, the agent does, if it's within reason that they should know this information.
Okay, now what if I'm a buyer and I bought one of these houses and it wasn't disclosed to me? How am I as a buyer protected?
So when we're dealing with one of the stigma things that I mentioned, so you find out after the fact, you're talking to a neighbor and they say, hey, I can't believe that you're living in a house that John was murdered in. So at that point in time, the only way that you could end up securing yourself and trying to protect yourself, if you actually wanted out of the deal, you already have the house. So the courts are at your means. Unfortunately, there's no guarantees. So what you would have to do is you'd have to prove that everybody should have known about this, in which case the agent may be liable. And I say may because it's very, very broad. But unless you specifically asked your seller, straight up, has anyone been murdered in this property? Has anybody committed suicide in this property? They had no obligation to disclose it to you.
Wow. So does title insurance come into play?
Title insurance will not protect you on these type of scenarios. When you're dealing, title insurance protects you on things such as mortgage fraud, title defects, back taxes. So if the seller never paid their property taxes but indicated that they did, happens all the time, then title insurance will reimburse you for that amount and go after the seller directly. If you end up having work orders, because that's a huge one that comes up as well, there's pros and cons of doing work order searches. So your lawyer can actually write for additional costs to the town and find out if there's any work orders or zoning issues with the property. So in a market that's very, very hot, such as right now, you're in a situation where you've probably negotiated this deal and there's no more flexibility, there's no more room. So you find out there's a work order, and it's great that you know that there's an issue that can be addressed, but the seller says, sure, there's a work order, but I'm not doing anything about it. So now I'm not going to give you any more money, I'm not going to fix it, and also, by the way, you have to disclose this information to title insurance because now you have knowledge there's a work order that you're not covered for. So it's the pros and cons of knowing the information. So sometimes it's good to know that information so it can just be dealt with if you're not worried about the money. Sometimes, you know, it's not always a good scenario to be able to have too much information because then your coverage gets affected by it as well.
I see. So sort of like buyer beware sort of thing. Should we come to a lawyer before we get a firm offer so they can maybe pull title for us and kind of tell us a little bit more information, or what do you suggest how a buyer can protect himself?
Buyer definitely needs to protect themselves in terms of financing. You want to make sure financing is done up front. You also want to have clauses, if you're concerned on an investment property, have a clause in there that's conditional upon lawyer review. At that point, the lawyer can have a look at the entire agreement. If they need to pull title, they can pull title at that point. Basically tell you, is there any issues with the property? The truth is that even if there is issues with the property, the lawyers still will address that before closing.
Right.
So it's not really a hindrance to proceeding, but it helps you negotiate, it helps you be able to know what you're dealing with.
Okay, thank you, Shell.
Pleasure.
That was part 4 of of the legal series.